SJC-11690, Commonwealth versus Miranda.
Ms. Baranoff, good morning.
Good morning. Susan Baranoff for Fagbemi Miranda. I am going to focus this morning on the first argument in my briefs, that is the violation of Mr. Miranda's rights to autonomy to testify and to effective assistance of counsel, and I hope I'll get a chance to also touch on the failure to charge self-defense, the fourth issue, in my brief. This case presents an unusual situation in which trial counsel pursued a defense, essentially that Mr. Miranda was not the shooter, his brother was, that Mr. Miranda rejected for strategic and personal reasons. He didn't want to blame his brother, and that directly conflicted with the defense that the defendant wanted and testified about, which was, I was the shooter, but I did it in self-defense or under circumstances that would be manslaughter or certainly without an intent to kill. Then trial counsel disowned Mr. Miranda's trial testimony by having him testify in narrative form, and he encouraged disbelief in Mr. Miranda's testimony in the way he made his final argument. All of this not only violated Mr. Miranda's...
He didn't really express disbelief, right? He allowed both, he sort of tried to present both defenses, right? You can either believe the defendant and you're going to lessen the, you're going to drop down from first-degree murder, or you're going to disbelieve Rice, is that her name, and then
Reese.
Acquit him, right? So he straddles.
I think that's correct. I think what he did belatedly at the 11th hour in his closing argument was to attempt some sort of dual defense.
Well, he's hoping, right, that the client isn't going to get up and perhaps perjure himself. Right until the end, we're not sure he's going to testify, right?
Well, the defendant makes it very clear throughout pretrial hearings that he does intend to testify, so it couldn't have been a surprise. Counsel must have seen this potential train wreck coming. He did testify.
It's a train wreck to have his client testify this way, so he's hoping that his client's going to see the light on that, right?
That was his judgment, but the client had other intentions and did testify.
Right.
And he did keep open his options until that point, but then when he gets to closing argument, that's when he attempts this sort of dual defense. But he leads with his attack on the Commonwealth's witnesses, particularly Ms. Reese. So
that was his defense, though, right? That was the defense he presented. That was counsel's defense, right?
that was counsel's defense. But the problem is it undermines Mr. Miranda's chosen defense.
Yeah, I guess that's the question. I mean, is there anything that says that a lawyer has to do what the client wants in terms of a defense?
That's a central question here. Does client autonomy give Mr. Miranda the choice? And I think in this situation where the choice of defense is so fundamental and so wrapped up with his right to testify, that should be his choice as a matter of autonomy. Also, we have here a situation where a defendant doesn't want to blame his brother, and that's the kind of personal objective in shaping a defense that the Supreme Court in McCoy thought was quite significant. There, McCoy didn't want to accept responsibility for murdering family members.
Yeah, I guess it's a question that I have is how could counsel avoid being ineffective here? I mean, what was counsel supposed to do? Just not put on a defense that he thought was the one that was possibly a winner? Or put on the defense his client wanted, which he thought was a complete loser?
I think he did some things right. He gave his client his professional view about what the best defense would be. He kept things open in the sense that he didn't commit himself irrevocably to his defense, although he pursued it. But once his client testified, to persist in the primary defense that he wasn't the shooter.
It was his
And-
brother that was the shooter. It had to have been his brother that, he didn't want to blame his brother, but that was the inevitable result of having that defense, right?
I'm sorry?
It was an inevitable result of having the defense that he didn't do it. It had to be his brother, right? Being his brother had to be, being the brother as the shooter had to be the inevitable result of the defense that was argued by
Yeah, there were
counsel.
only two of them there. There wasn't a,
Right.
the testimony
But it had to
wasn't
be his
that there
brother.
could have been some mistake about who was on the scene.
It had to be his brother, and he didn't want to blame his brother.
He didn't want to blame his brother.
Right. Yeah.
And was clear about that.
From the
From the
beginning.
start.
From the beginning. And isn't that why he discharged his last lawyer, Moses? Because Moses wouldn't go along with it?
It seems that the same impasse had been reached with Moses.
And so this lawyer going in knew that that impasse had taken place and tried to withdraw also, didn't he?
He did try to withdraw,
And wasn't allowed.
rather late in the game,
No.
but he was not allowed to. So I don't deny that he was in a difficult position, but he knew that his client was probably going to testify. His client did testify. And at that point, to put him up on the stand without preparation in narrative form is a
And by
clear...
his associate, apparently.
Pardon?
By his associate, Mr. Freitas.
Exactly, who had really not been handling any witness until
But
then.
there was no witness that he handled. There was no other witness that Freitas handled. Freitas
Not that
only
I
handled-
recall. It was always Mr. Camera. So, another way of kind of distancing himself
Yeah.
from his client.
There's a lot of questions on the issue you're on, and I'm not asking you to move off of it, but I just want to ask you the question on the self-defense. If there's, I know you said there was enough for a self-defense instruction, but if there wasn't enough for a self-defense instruction, and that's the defense lawyer's judgment, the only chance the defendant has is to distance himself from the self-defense that's not going to be instructed on and try to have another argument. And I know that leaks into your self-defense point,
Right.
and I do want to compartmentalize them because there's so many interesting issues on your first issue. But you can't blame the defense attorney, who's in a very difficult situation, for trying to distance himself from an argument that had no chance of getting a jury instruction and trying to see if he could at least put something together for something that might help his client. So if there was no self-defense available, I know that's a big if in your view, then what choice did he have if he was going to zealously represent his client?
Well, in the first place, the judge himself originally thought he would charge on self-defense.
I understand.
And that was open to him to argue in closing before the judge changed his mind. But I see the defendant's testimony as sort of a continuum. It's not, he is testifying, I thought I acted in self-defense. I thought he was reaching for a weapon, he had a weapon, and I shot. But he also described the circumstances under which he shot. And there was certainly an argument that those were, and defense counsel did make it sort of in the alternative, that this could have been manslaughter. And he also testified, no way did I intend to kill this man. So that would have diffused deliberate premeditation. So if the suggestion is the defense built on the defendant's testimony was hopeless, I don't think that's
Are you
accurate.
saying if it had been structured on a direct examination, it would have been different, as opposed to having the client testify in a narrative form? Did the narrative form impair the representation?
The narrative form absolutely impaired the representation. This court recognized in the Mitchell case that having a criminal defendant testify in narrative form threatens his right to testify, to a fair trial, and to effective assistance of counsel. And it only allowed an exception in a case where defense counsel has a firm factual basis for believing the client is going to commit perjury, and this was not the case in this case.
Let's say,
Really? It's not the case? It's not a case that he doesn't have a firm factual basis for believing that he's going to perjure himself with this? Really?
Trial counsel never so suggested. The defendant's testimony that he was the shooter actually lined up with the Commonwealth's witnesses, particularly Kim Reese, suggesting that he was the shooter.
Which is, but in great inconsistent with the other two witnesses or not? There are two other witnesses,
The two
right?
other witnesses, Andrade kind of contradicted himself about who passed the gun to whom, and the third witness didn't really see that. So this is not a perjury case.
I was going to say, this is not, so if it was certainly a Rule 3.3 case, the defense counsel did the only thing that he could do.
If that were the case, yes.
But the judge allowed him, I mean, this is sort of a backdoor 3.3 is sort of what it looks like, frankly. Defense counsel doesn't want to go forward and say, I think my client's perjuring myself, but I want to do exactly what I would do if I did believe that, which is stand apart from it.
I don't think this is a backdoor 3.3 case. I think the thrust of everything that defense counsel said was, I think he's chosen a disastrous defense, not that I think he's lying. And I don't think you can get perjury out of
What
the
about what seems like a
circumstances
wink
that were
and a
known to
nod?
him.
What about what it seems like, if you look at the colloquy between himself and the judge, he says something that suggests that maybe he's thinking about perjury, like, I'm not fully aware, despite my best efforts to extract every nook and cranny, which makes me a little uneasy as to directly questioning him. Best suited for him to do his narration. And the judge says, you're concerned being because you're not completely confident about what he's going to say. And he says, correct. And then it goes on to say, I can't obviously know would I ever vouch for the credibility of any witness. Isn't that sort of a wink and a nod to the judge saying, hey, you know, this guy could perjure himself? Which is what Justice
Oh, I don't think so. I
Gantz
think
is
it's just,
suggesting as a backdoor.
if anything, I think it may indicate that he didn't really completely prepare. And I don't think he's saying,
You don't think
Oh,
that
he's
that's a way of, you don't think that's a way of saying to the judge, listen, I think I'm also worried about perjury? I'm also worried about perjury. You don't think so?
I don't think so. Plus, you have to look objectively at the
But
circumstances.
add the
Even if
fact that he's tried to get out of the case, and the prior lawyer also tried to get out of the case, and successfully did so, and we're running out of options, particularly because the client doesn't want to defend himself, right? Am I mixing this up with
he did
another
not
case?
want to defend
Right,
himself.
so the client doesn't want to defend himself. We're on lawyer number 2. There's certainly a whiff of perjury here, if not an express statement of it. He's walking this complicated 3.3 line, and he's come up with sort of a relatively smart way of doing both. He's putting out the defense that he's, you know, one, you can believe him, and also you can believe, hey, he's trying to protect his younger brother. I don't know, it just seems like it's in certain ways masterful given the mess we're in.
Let me compare how this was handled with what defense counsel did in the Salazar case, which the court decided last year. There, the defendant testified, it wasn't me, somebody else did the killing. And there was some evidence of intoxication. Defense counsel there kind of walked that very difficult line of a dual defense by arguing.
soft pedal,
What?
soft pedal.
Yeah, arguing consistently with the defendant's testimony and then soft pedaling the intoxication, not even arguing it in closing. What we had here was completely different. You have, you know, putting the person, you know, at arm's length, the narrative testimony, and I don't agree there was a whiff of perjury here or a firm factual basis that would allow that to be done. And then, you know, the argument is primarily don't believe the Commonwealth's witnesses, including Kim Reese, in closing.
Ms.
And
Baronoff,
you don't have to believe the defendant either. The Commonwealth wants you to believe the defendant.
can we
And
just
then,
take your argument as let's say that you're right. let's say that it was error to have the defendant have to testify in a narrative form. Because, as you pointed out, this is not 3.3E, so just assume for the question that it was error. What's the standard of review here?
If the client's right of autonomy was infringed, and we say that it was in various ways here, that's structural error. A new trial is to be ordered. There's not a requirement of showing of prejudice.
If he were deprived of his right, that would be, but he's allowed to testify. If we found 3.3 testimony, I know you're debating whether it's a 3.3 or a backdoor 3.3, but have we ever found that when a client was allowed to say exactly what he wanted to say, that's a violation of client autonomy?
If defense attorney then undermines his client's testimony using narrative form and the way he argues,
Well, you're assuming
that can still be a violation of client autonomy. In McCoy, the defendant testified, and there was still a violation of client autonomy because of counsel's concessions.
But he concedes guilt in that case, right? Your
It is-
client, he doesn't do that in this case.
It's not as dramatic.
And
I agree.
actually, he's saying if you don't believe them, I mean, he's presented a theory where Reese is lying. There's someone saying that the defendant got in the way of his brother, right? He pushed him back in, or grandma pushes him back in. The defendant also doesn't want the brother that involved, right? There's some pushing him away, right?
He doesn't really do much with that in closing.
It's just,
He doesn't really even deal with the Zanetti issue at all, which is another concerning aspect of.
yeah, that's a tricky part, the joint venture part.
So what should Mr. Kammerer have done?
I think he should have adopted as his primary defense what the defendant said. At very most, he could have argued in the alternative. If for some reason you don't accept his testimony, you're left with this incredible testimony by the Commonwealth witnesses and you shouldn't convict.
That argument only works if there's grounds for a self-defense, right?
Well, he can not only argue self-defense, but he can also argue mitigating circumstances, so it would be manslaughter. He can argue not second degree. He did sort of do a little of that in the middle of his closing without marshaling the facts, but it isn't self-defense or nothing. He could certainly argue that based on his client's testimony and marshal the facts, he thought he was acting in self-defense. There were mitigating circumstances. He didn't intend to kill.
What is the best argument for self-defense? Tell me what the facts are that support a self-defense.
It's the defendant's testimony.
Forget how he testified, but
He testified that initially Mr. Barrows punched him without provocation. When his brother came to try to separate them, and the brother had a gun at that point, but Mr. Miranda didn't, Barrows threatens to kill the brother. And then in the driveway,
the alleyway.
he says,
Is it an alleyway or a driveway?
we're in the driveway,
Okay.
and Mr. Miranda says, I saw him reach for something near a window. And then a little bit later, I saw him holding something that looked like gunmetal, like nickel-plated. I thought he had a gun. The testimony went back and forth. You have to realize that he's testifying in narrative form without any help from his counsel, but I think the
So you're saying
best
those
version
facts-
of his testimony.
But what about the duty to retreat?
Pardon me?
What about the duty to retreat? That he doesn't,
What he says is, I can't imagine why this guy would have gone into this dark driveway, except it's a known stash area, so I'm concerned he's going in to get a weapon. My house is directly across from the driveway. If he's got a weapon and I turn around, I'm liable to be shot in the back. It's sort of an Ortega situation, that case decided by the court.
so you're saying that it meets, if barely, it meets all the touches on all the points that are necessary
Right, as
for...
the standard is very low
Yeah.
for qualifying
How
for
far- How far is that?
this defense.
When he's at one point the two of them are chasing Barrows. How far is Barrows going to this broken window? I'm confused how long they have to run after him. And how quickly can he get to this broken window where supposedly the gun is stashed? Where is that in relation to where they're having this argument?
It's not very far into the driveway, as far as I understand. The testimony, and you'd have to look at the pictures as well, the photos as well, which might be helpful, isn't very clear. But Mr. Miranda says in his testimony, this all happened very, very fast. This was not a dragged-out event where they're in one area. You know, it takes a while for him to get into the area where the window is.
So when they
and then-
pursue him, they're pursuing him like a matter of feet into the driveway, or are they pursuing him into an out? I'm confused by where they're pursuing him, because that's going to be the critical issue on duty to
It's just-
retreat, right?
Mr. Miranda testified that he went into the driveway, his brother didn't, but not that he pursued him all the way to the end of the driveway where where he saw what he thought was a gun and where Mr. Barrows was when he was shot.
That was a driveway or an alleyway, because there was a fence.
It's a driveway with a fence at the end.
And some sort of
Driveway with a
platform?
fence at the end as opposed to a garage at the end, or just a, I'm
It
just trying
was,
to visualize it.
yeah, it was blocked off.
Is there a picture of this in the record?
Yeah, we're in the
Pardon me?
Where in the record is the picture of this?
There were photos introduced. I'm not remembering that we put them in the record appendix, but they would be
Bad.
available.
You can get the exhibits.
Yeah, well,
Okay.
Yeah.
All right, thank you.
Thank you.
Mr. Nadeau.
Thank you and good morning. May it please the court, Stephen Nadeau on behalf of the Commonwealth. Your Honors, I'd like to begin with the availability of a self-defense claim in this case, because I think that then casts light on the counsel's assistance piece of it. The problem with the defense argument is that even if Christopher Barrows ran down that driveway and actually reached for and actually grabbed the firearm in the driveway where the defendant shot him, and even if he had pointed it at the defendant, the effect of the defendant's testimony was to admit that he killed someone who was acting in justifiable self-defense. Self-defense was available here to Mr. Barrows if there were any indication he had done so. There was no evidence of an overt act, but it was Wayne Miranda who introduced the threat of deadly force into this altercation, and it was the defendant who joined in that venture when he joined the pursuit after Mr. Barrows turned his back and fled.
to an area that was known to be a safe place for putting weapons and stuff like that, right? It was an area that, there was testimony that it was a bad area, that everybody knew that that was where stuff was being hidden, and that he saw him take something from there. It looked kind of shiny to him. And he'd already said he was going to, he
he
threatened to
did
kill
not-
both him and his brother.
Sorry.
I'm sorry, too. Go ahead.
As I recall the facts, the defendant testified he didn't see or did not claim to see Mr. Barrows reaching for anything until after the pursuit with the gun had begun, until after they had already followed him to the edge of this driveway. So at that point, Mr. Barrows arguably is availing himself of a avenue of retreat, or B, someone's chasing him with a gun, he's running to a stash to defend himself. But even if there's this general awareness that that window is a stash spot, running towards it, I don't think could constitute an overt threat under the cases where even having a firearm actually in your hand at the time may not rise to that level. But again, even if he had, it was the defendant and his brother who introduced the deadly force into the equation here.
The fact that they introduced the gun into the mix, does that answer the question? I'm a little confused by that. 'Cause
I'm sorry, Your Honor?
the fact that they introduced that the brother brings the gun into the mix, that if he's running to the stash So the fact that once they put the gun in the mix, then it doesn't matter if he's running to the stash to get the gun? I understand the argument that they could leave, they could retreat as he runs to the stash, because he doesn't have the gun in his possession. But the fact that they put the gun in the mix means that there's no self-defense as opposed to excessive force? I don't know, I'm just trying to understand that, yeah.
Well, I think to say that either the Miranda's had a self-defense claim here would essentially swallow the concept of self-defense, and that you can bring a gun into what had been a...
Right, but it's Wayne it's the brother who brings the gun into the mix. And we're
True.
dealing with a defendant. So does that matter?
Well, the defendant must clearly join in the attention at that point when he follows him, affirmatively takes the gun from his brother, and fires at the person who had just been fleeing for, as it turns out, his life.
Although I thought there's some testimony, I understand this thing becomes a total chaos, but there's some testimony to the fact that the brother brings out the gun and the defendant is trying to get him to go back into the house or something. I know the grandmother's trying to put him back in the house, but the brother is pushing him away.
There's the initial testimony that the defendant does, I suppose to his credit, try to push Wayne back.
Right. So does that, the facts are so jumbled, it's hard to follow, but if the brother comes out with a gun, the defendant pushes him back into the house, the other guy runs to the stash, which supposedly has a gun, still no self-defense instruction for the defendant?
In that case, the defendant might, I suppose...
It's closer.
I mean,
Been nice.
I understand that's the complicated thing, but I guess
Been nice of the
there, the
judge.
defendant at least, I'm sorry, could say that, you know, I tried to avoid this deadly altercation, and I didn't resort to deadly force until, you know, I had neutralized my brother, pushed him back in the house, and nonetheless, this guy still went and got the gun and pressed the issue. But whatever reluctance the defendant may have had, certainly the facts seem to suggest he's made the determination, well, if we're going to do this, we're going to do it. And by his own admission, chased a fleeing man into a driveway where he shot him, and as the evidence was consistent, he was going over the fence.
Mr. Nadeau, I agree with you that starting with self-defense makes sense here, because if there is no possible self-defense, what chance does the defendant have other than his attorney divorcing himself from the self-defense?
Correct.
So I understand that. But if I could just follow up on Justice Kafker's line of questions. You know how we have cases where there's deadly force used, and if the defendant's the one who initiated the deadly force, initiated changing the nature of the confrontations from a physical confrontation to one with some sort of a weapon, for instance, there are circumstances where the defendant wouldn't have an available self-defense since the defendant upped the ante. So what I would like to know is the same question that Justice Kafker is asking, which is, if, maybe the light most favorable to the defendant, the evidence is better than what I'm going to say, but if what happens is there's some sort of physical altercation going on, and the victim at some point takes off, retreats, without a gun, and the defendant brings a gun to the confrontation, if the victim at that point reaches for a gun, does the defendant, if he shoots him, have an excessive force self-defense? Or is it that, no, the defendant was the one who created the situation, upped the ante, and there is no excessive force self-defense, or straight self-defense for that matter?
And so if I'm understanding, the altercation begins as a physical one, but not with deadly force?
Yeah,
So fisticuffs, maybe?
or an argument, with even a chest-to-chest argument.
Well, I think, and I don't have the citation in front of me, I can follow up with a letter. There's a case, Commonwealth versus Walker. I know that says that, you know, if the case presents an issue of non-deadly force, the defendant's not entitled to deadly force instruction, or if the evidence is deadly force, he's not entitled to a non-deadly force instruction. So where there's only been a altercation not involving an overt act or threat constituting the deadly force or the threat of it, you're not then entitled to introduce deadly force into what has prior to been a non-deadly altercation, or without the threat of that outcome.
But the tricky issue is, isn't it, the tricky issue is the duty to retreat. When you bring the gun to the game, they run off. At least, I think the harder part is the brother brings the gun into the game. If he brought the gun in the game, the guy ran off, he could get out of there, I assume, and retreat. The question is, when his brother brings this gun to the game and the guy's running off to get a gun, can he retreat without worrying about being shot? I don't know the answer to that question, but that's the hard part of this, right? That is the duty to retreat somehow precluded by the possibility that this guy could get to that stash fast enough to take a shot at him before he could get out of there, or something like that.
And I think the factual link there is too conjectural to constitute the overt threat.
When the judge denied the self-defense instruction after thinking he or she was going to give it, did the judge provide the explanation for that? Don't remember.
I can't recall if he made a specific citation. I know that there was that back and forth in the decision prior to, but I apologize.
No, it's a messy record. I get it.
So do we know, I mean, are there diagrams in the record indicating the distance between the altercation on the street and the fence where he ultimately died?
I don't think there's any in the record appendix itself. I recall, I don't know if they were exhibits, but I know when I was looking through our own file, I did see some photos, but I couldn't.
So we need to get the exhibits to get a visual sense as to what occurred in this case.
Sure, but I think even in the light most favorable to the defendant, his testimony doesn't come down to that level of.
Well, but I mean, it's not merely bringing a weapon in. It's the threat of deadly force that you're arguing. I mean,
Right.
Sadly, people carry weapons all the time, but the mere fact that you're carrying a weapon does not necessarily mean that somebody can then point it at you as if they're going to shoot you, and then you can't shoot back in self-defense. It's only if they're acting in self-defense that you can't be claiming that you're acting in self-defense.
Right, well, otherwise it would set up sort of a kind of perpetual motion back and forth. Well, he pointed it at me, so I get to point at him, and now he's pointed it at me, so, and on and on. But here, as I began the argument, I mentioned even if the defendant saw Mr. Barros actually grab a firearm and point it in a threatening manner, Mr. Barros would have been acting in self-defense, but the defendant's testimony does not establish even that. It's that he may have been reaching for this item. There was no description even at any point of an overt act. There was no description of any attempt to avail themselves of an opportunity to retreat. In fact, the defendant was very clear he did not believe he had that obligation.
Well, he also had not been prepared by his lawyer to testify.
I don't know that, and granted,
I mean,
there
we
was
do
no
know,
evidentiary
we
hearing.
know, for example, that he didn't raise the adjutant motion until after the testimony was over, right? And we know that he didn't get the documents that were related to the criminal record of the victim, which had been allowed by the judge, and this lawyer never picked up those records. So we know that too, don't we?
Right, that's true, but
Never really did prepare a self-defense defense, did he? Even though he knew his client wanted it.
And, well, absent, the benefit conceivably of a evidentiary hearing, we don't know exactly what the nature of the conversation between counsel and defendant were, but we can figure it was probably substantial given that he'd already had to get rid of one lawyer based on this disagreement. So Attorney Camera takes over his representation knowing this is sort of...
And doesn't do anything about it. Continues on with the defense he wants to make.
And found as the defendant showed when he testified, there's nothing here
How do you
except a
know that, though?
confession.
How do you know that, though? How do you know it wasn't, was adequate preparation, that there couldn't have been something that came out differently? How do you know that?
If you look at any other aspect of the counsel's approach to this trial, it seems he was very well prepared to defend
For a
this case,
defense, for a defense that the defendant didn't want.
which was no defense at all. It was essentially a confession.
Well, it was self-defense the way it was presented, as opposed to the way it could have been presented.
But it was clear that counsel had made the decision after representing, his client for some time, that there was no self-defense here.
I
And
know,
in
but
fact-
is that the end? Is that the end, though? Is that the end of the question? Is he not be duty-bound to do something else, something more?
I'm
So
sorry?
Isn't he duty-bound at least to investigate? Isn't he duty-bound at least to try to prepare? Knowing that his client is going to testify, knowing that. He knew it because he's been very consistent about this, with his last lawyer and this lawyer. Didn't he have a duty to somehow represent his client in the way the client
Maybe,
wanted?
but if the testimony here, if what the defendant is telling him was as he testified, I joined my brother in this pursuit of Christopher Barros as he was running away down a driveway.
The driveway was known for having things in it that were possibly
Right.
weapons.
But this was after Wayne had begun chasing him in that direction, that he moved there. And at best, you have Christopher Barros reaching for something, maybe a weapon, maybe
Doesn't he
not.
say later he has something shiny in his hand that he sees?
Yes, yes.
And Barros has
And
threatened
he does
him
at one
and
point
his
say, I
brother,
think
right?
it's a firearm.
He's threatened his brother and himself with death, hasn't he?
I'm sorry?
The victim has threatened both of them with death. Threatened to kill them, didn't he?
I don't believe even in the most charitable view of the defendant's testimony that threat, are you talking about the, I'm gonna kill you?
Yeah,
Well, at that point, when he says that, he is unarmed. The defendant conceded at that point, no weapon in his hand. There's a verbal argument.
I'm going to kill you because I'm going to go into this alley and I'm going to get the weapon that I'm going to kill you with.
Well, that would
Is
again
that the
been
charitable reading?
after.
Isn't that the charitable reading?
I'm sorry?
Isn't that the charitable reading?
Yes. But this was, again, after the co-defendant or joint venture, his brother, had emerged with the gun as an overt threat against Mr. Barros himself. This isn't the case where Mr. Barros, and the argument escalates and he says, I'm gonna kill you, starts running for this stash gun. And then Wayne Miranda feels compelled to run in the house, grab a gun for his own defense of his family. Wayne Miranda comes out with the gun to threaten Mr. Barros first. And at that point, I would suggest what, even in the light most favorable to defendant, everything Mr. Barros is doing, even if he were going to get a gun, even if he had gotten a gun, would have been in justifiable self-defense. But there was no evidence that he actually reached for a gun or had one in his hand.
Can I ask one? When this starts, are they close to their own house? How far is it? Do we know from, I mean, obviously we don't have the pictures yet, but can they quickly go into their house much more quickly than Barros can get to this stash? Do we know anything about how far away everyone is from everything?
Again, I don't recall the exact measurements, but this all, I know, I think the defendant is sort of down the steps. And the grandmother is on the patio, but
Right.
again, but I don't think the analysis really turns on the specific placement of the people because the Miranda brothers had, again, introduced deadly force here. And
I want to switch issues for a second. When they tell the judge they're going to do the narrative for them, do they introduce Rule 3.3? Is that discussed in the transcripts or anything?
not explicitly, no.
So they know this, because it's not something everybody seems to know, but they know the narrative testimony option, but they don't, and the judge gives the colloquy about the dangers of testifying through a narrative, right?
Yes, yes.
So they clearly are aware of Rule 3.3 and the case law, but they don't talk about it?
That's my recollection.
So there's no overt representation or implicit representation by defense counsel that this is a 3.3 case?
Correct, and I don't think counsel, even Attorney Moses, ever specifically say he's lying about this. I think they kind of characterize it as we intend to argue, or Moses said, I intend to argue that he's not to be believed, which is close but not the same thing as saying he's actually lying.
Mr. Nidu, let's just for a moment say that having the defendant in this situation have to testify in a narrative form was error. What's the standard of review?
For narrative testimony would be an abuse of the judge's discretion. And if it were, I don't believe there was an objection at that point. It would be substantial likelihood of a miscarriage of justice under 33E. If it were truly client autonomy, I think the reading of McCoy versus Louisiana is correct. It would be a structural error, but...
So let me ask you about substantial likelihood. So the defendant is being told that he has to testify in a narrative when he's got an attorney who's requested it. The defendant is hardly in a position to preserve the record and object. Is substantial likelihood a fair standard of review if it was error to testify in a narrative?
I think so, because there was a colloquy where there's no indication that the defendant, other than this strategic disagreement, was displeased or felt under-advised in any way by his lawyer. And
You say that there was a colloquy? I didn't see any colloquy. So that might affect
I can get that.
the review.
I have that in my brief as volume 6 of the transcripts, the trial transcripts, pages 3 to 7.
Okay.
And that's where he acknowledged counsel's advice that he shouldn't testify, agreed that the representation and trial practice had been satisfactory in other respects, but still wanted to testify.
But not necessarily warning him of the dangers of testifying in a narrative, as opposed to having his lawyer ask him questions. Is that?
But I believe when they're having that exchange, it's already clear that the narrative is going to be used. And that's sort of what the discussion with the defendant is about. You understand what the procedure is going to be. You understand your attorney's position. Having said all that, you wish to go forward, and the defendant agreed to go forward.
So what you're saying is to get a standard of review that's preserved, the defendant, represented by counsel, would have to say, yes, Your Honor, I understand, and his representation in this issue has been fine, but I object to testifying in a narrative form, even though my counsel's requesting it, and here are the reasons, and that's what a defendant is supposed to do to get a better standard of review?
Isn't it ineffective assistance of counsel? I mean, isn't that how we have to look at this? We can't look at this through objections or non-objections, right?
Correct.
Right, yeah.
And I think your characterization of it as, in certain respects, masterful was the assistance.
Well, I'm less certain at this point.
But your point is that the ineffective assistance of counsel, if there is ineffective assistance of counsel, we need a record after a motion for new trial based on ineffective assistance.
Right, that would certainly help develop the record, but again, on the facts here, where the defendant's attempt to pursue an unavailable self-defense claim amounts to a confession, because self-defense is not available to him.
But that ignores Justice Link's questions. Her questions all go to, well, maybe he didn't investigate it enough. Maybe if he directed the examination without suborning perjury, he might have addressed the narrowness and and whether retreat was feasible. Maybe it would have strengthened the record on exactly what was observed. All of her questions go to whether or not maybe testifying in a narrative was ineffective, and maybe it was, I don't know. But we don't have that record. There needs to be a record from a motion for new trial with that, doesn't there?
I think if there were any view where the defendant was entitled to self-defense, that would be a colorable argument, but where it's not, simply not available to the defendant. And I think the reason two lawyers, the trial judge, tried to explain to him, this is very, very dangerous to you, and the reason that the judge, in his decision on the motion for new trial, said this was a poor choice, to say the least, was because the defendant's decision to testify as he did, and as he had apparently planned to all the way along, was catastrophic for his defense. And what trial counsel here tried to do was mitigate the damage the defendant did to himself every step of the way. And the defendant now wants to shift that blame onto counsel who tried to protect
But
him.
I'm trying to sort out what a lawyer is to do in a situation, and we don't know enough here, but I mean, imagine a situation in which the defense lawyer says, okay, what happened? And defendant says what happened, and the defense counsel says, well, that's a loser. If you argue that, you're going to lose. I'm not going to have a self-defense instruction. If you do that, they're going to find you guilty for sure. And the defendant says, well, that's what happened. I don't want to argue that my brother did it because it was me who did it. What's a lawyer supposed to do? Supposed to do what this attorney did, which is essentially attempt to say, I've got a better argument and make it? It's a challenging circumstance.
I think it's absolutely challenging, and I think what Attorney Kammer did was the best he could do. It was certainly effective. I mean,
Well, it wasn't effective,
it wasn't
obviously.
it wasn't ineffective, constitutionally speaking.
Didn't work.
But he did leave them out there. I mean, it's one, if you have a Rule 3.3, then you're obliged under the rule to require him to proceed with a narrative. But in the absence of 3.3, is there any circumstance in which an attorney can leave a defendant to give a narrative without questioning?
Again, I think that would be discretionary with the trial judge under particular circumstances. And I think even if it's not a perjury matter, and indeed I think the Commonwealth wanted the jury to credit the defendant's testimony in certain respects. But the issue here was not about necessarily, although there is a whiff of it, I don't want to suborn perjury. It's that this defense is no defense at all. If, you know, a client wants to plead guilty or admit to a crime and get the best deal he can, that's one thing. A lawyer can represent him. But to say, my trial strategy is, again, not what the defendant had hoped for, but the effect of it was to admit guilt, essentially, because no defense was available to him.
But I thought that the argument to the judge was that I'm worried about him getting impeached if he testifies, not I'm worried about the self-defense. I'm worried about him getting impeached by his prior record. That's what he was saying to the judge.
Sure, and that was one of the concerns.
Not a question of whether the judge has the authority to do this. It's a question of whether or not the lawyer should have even tried to do it, asked for it. The lawyer, it's on the lawyer, not on the judge.
Well, I mean, it's hard to say the lawyer should have asked for it when the
Should not
judge
have
has already
asked for it.
determined it wasn't available.
Should not have asked for the narrative, is what I'm saying.
Oh, again, I think the effect of the defendant's own decision to testify was on its face, as the record makes clear, disastrous enough that it made sense for counsel to say,
Only if it's a backdoor 3.3, right? Everything he does makes sense if it's a backdoor 3.3.
Sure.
He doesn't try to glamorize the defendant's testimony. Under Rule 3.3, what can he do with testimony that he's not confident isn't suborned perjury, right? He can't use it in his closing, right?
right, and
So what he's doing makes perfect sense if this is a backdoor 3.3, but without 3.3, he's in serious trouble here in terms of ineffective assistance at counsel. Right? I mean, you need 3.3, don't you, to make this make sense?
Again, maybe it's a philosophical disagreement, but I just don't think so. I'm not aware of any authority that forbids it. I don't believe any was cited specifically by the defendant, and as I understand it, that would be discretionary. And again, here, the defendant was sort of explained and indicated to the judge that he was amenable to the procedure.
I mean, washing his hands of the defendant, basically. You know, let my associate even put him on. I don't even want to do that. I don't even want to be seen as having anything to do with that defense. Is that what he did?
Yes, but sort of washing his hands of his client's effort to inculpate himself.
No, to present the defense he thought it was there. And I'm not sure that there's ever anything on the record that makes it clear that he's explained to his client about that. That's why he shouldn't testify.
Right, well, I think when he says it would be suicidal speaks to that, and certainly
Because he's going to get
suicidal in
impeached. Because he's
comparison
going to
to
get
the best
impeached.
available.
He's going to get impeached by his prior record. That's why it's suicidal.
I guess I didn't read it as specifically directed only to the worry about impeachment, but
Right, maybe
to
I'll
the
go
fact
back
that
and
both
read
lawyers involved in the case did not believe self-defense lied here.
Okay, thank you.
Thank you.